I'm Lydia Tasevska and I'm a family lawyer at Mills Oakley. I'll be talking to you about special skills in terms of owning a business and also about valuing your business. You own a business, you might have separated from your spouse or your de facto partner, or you might be happily in a relationship. You might ask yourself, what will happen to my business if I was to separate? In family law, one of the first things that we do is we look at all the assets and we look at all the liabilities of that relationship or marriage. So this will most definitely include your business. Now that business could be in your sole name, that business could be owned by a partnership, it could be via a corporate entity, or it could be run by a trust. So once we get an understanding of all of the assets that form part of the pool, we'll also then need to find out what the value of that business is. Because we look at all the assets, your business will be included in the pool and we'll also need to ascribe a value to that business. So the next step that we look at is contributions. So we'll look at financial contributions and we'll look at non-financial contributions, okay? And those contributions can include parent and homemaker. So I guess at this point is where you might ask, well, you know, hang on a second, I've been in a long relationship, I've built this business up from scratch, it's been very successful, why should my spouse or de facto partner have a share in that? You know, I've had a special skill that has contributed to this asset being valuable. You might also ask, well, it was because of my business acumen, it was because of my skills and endeavours as to why that business is now quite valuable. So back in the days, this would have been considered as a significant contribution by that particular spouse or partner as a special skill, and they most likely would have received a greater portion of the pool. However, recently, because of family law decisions, there is no longer special skills, and what that means is that you won't, in practical terms, it doesn't mean that you will get a greater portion of the asset pool. Now, you might ask, well, you know, why is that? I've worked so hard to build this business up, why should my spouse or partner take a share of that? Well, the reason for that is because in family law we look at, as I said previously, financial and non-financial contributions, and they both hold equal weight. So just because you're the breadwinner and you go out there and you earn an income and you've created a successful business, it doesn't mean that you're going to get more of the pool. Because the way that we family lawyers and the court as well, the way that we look at it is a financial contribution is as equal as the spouse or the partner that stays home, looks after the children, and also takes on the primary homemaker role. Okay, so one contribution is not greater than the other contribution. So because of these recent family law decisions, your special skill in generating a substantial income from that business, in creating a successful business, will hold no greater weight than a contribution as a parent or a homemaker. One way to protect your business is to enter into financial agreement, which is colloquially known as a prenup. These agreements can be entered into either before a relationship or during a relationship or a marriage. The effect of these agreements is that it can quarantine the business for you to solely keep that particular asset, and you take it out of the hands or out of the reach of your spouse or partner. If you have recently separated or you do want to protect your business and you're considering entering into a financial agreement, I strongly recommend that you seek family law advice with one of our family lawyers here at Mills Oakley.